It's time for another edition of Lewis at Large, 60 minutes of smart talk radio featuring guests from all walks of life in conversation with your host, Warner Lewis. So sit back and lend us your ears for the next hour. Now here with today's first guest is the host of Lewis at Large, Warner Lewis.
Well, welcome everybody to another edition of Lewis at Large. Yours truly, Warner Lewis from the flight deck, and of course that means some smart talk radios in your future, and this segment is no exception. But before we get to our interview, do want to remind you again, shows are archived on YouTube, and of course you can check us out at lewisatlarge.com. When you go to YouTube, you go to Lewis at Large Radio, and you can see lots and lots of archived shows there. Type in the name of a particular guest or subject, and it will take you right there. But to the matters at hand, we're talking to Sally Kelsey, and we're going to be talking about workmen's compensation, which in some 650 shows, we have never specifically talked about that. We'll talk about a little bit more than that, but the primary focus today is workmen's comp. What does it mean? What does it mean to you? What does it mean potentially to the company that you work for? Sally has been a lawyer and practicing attorney for almost 3 decades now, specifically, well, not just specifically in the area of workmen's comp, but that is certainly a specialty of hers. We'll get into that a little bit more. Sally, how are you, my friend?
Just fine. Thank you.
Well, we're very happy to have you here. Let's start with some very, very basics here for our Lewis at Large listeners. Tell us a little bit, what is workman's comp and why laws, and tell us when did, in essence, the concept of workman's comp really come to being?
Well, in the past, the only workers' compensation, the only opportunity that workers had to get some kind of recourse when they were injured is to sue their employer for negligence that may have caused the injury. And of course, this type of situation is problematic for a couple of reasons. Number one, if you litigate a case, it takes you about 2 years. And of course, when you're injured at work and you are a family member who's the provider, you need to get food on the table, you need to get benefits right away, so that was problematic. And secondly, it's obviously a concern for the judicial system to have all of these types of cases in the judicial system and slowing it all down. So initially, the cases or the countries that began to do this were Germany and Prussia in the 19th century, and it only came to the United States in 1908 when the U.S. Started providing workers' compensation insurance coverage for some of its employees. And since that time, all the individual states have gradually added a Workers' Compensation Act to their laws, and that essentially provides that employers have to provide insurance coverage for 3 things that the law provides, and those are essentially weekly benefits for the time that you're off of work, medical benefits, and compensation for any permanent disability that you have. And obviously this is the purpose of this is to streamline those benefits to make sure that employees get covered for basic things so that while they're being treated and getting better, they're still able to have an income, and the employer can hold their job until they're able to come back to work. And all of this is done through an administrative system that doesn't have any significant impact on the court system, because it's an administrative system administered by in our case, the Kansas Department of Labor Workers' Compensation Division.
So you said that the U.S. really was a little bit tardy in adopting some workmen's compensation concepts in the early 1900s. Should I assume that was sort of a result of the Industrial Revolution, where we now suddenly had lots of people working in factories, so to speak? Was that, do you think, where the real origins were?
Sure. It's actually the late 19th century that it started in Europe, and here in the States, 1908, 1911 is the first time that a couple of states, Washington and one other state, started the system. And what they built is a system essentially designed, for the most part, on the one provided by the laws in Prussia over in Europe. And the framers of every state have done essentially the same things, but over time, legislatures have modified and expanded and contracted all those benefits. And I would say one important element of the entire system is that it is a legislative compromise. In the early beginnings of our country, the U.S. Supreme Court established that there could be no law passed by the government that says that one group of people or one type of individual cannot sue another person for their damages. You can't have a law saying farmers aren't allowed to sue other farmers, or people can't sue somebody for a manufacturing defect. That is unconstitutional because you have a right to recourse in the courts. But the Workers' Compensation Act is actually an act that says employees, when they're hurt at work, are not allowed to sue for their damages. But in exchange for that, we're going to provide that the employers have to provide these three basic benefits, and those are the weekly benefits, the medical providers for them, and compensation for permanent disability. And over time, like I said, those have expanded and contracted. And so currently in Kansas, they've contracted to a degree where there's actually been some constitutional concerns raised by a number of groups, including employers, because if Workers' Compensation Act is illegal and unconstitutional because it really doesn't provide anything in exchange for giving up your rights, then if the Work Comp Act is invalid, then employees can sue their employers and obtain much more compensation for their actual damages than workers' compensation provides. Workers' compensation laws are considerably limited when compared to, say, a personal injury case. They don't include pain and suffering. They don't include compensation for lifetime of disability. They essentially are limited to a total payment for up to 8 years. They include a maximum cutoff of $130,000 for your lifetime of payments, and if you're totally disabled, $155,000. So you can imagine if you're making $60,000 a year doing some skilled labor and you have an injury that causes you to be unable to work, that's not going to go very far. You're going to end up, frankly, on the Social Security rolls probably, and the federal government is going to have to provide some type of benefit for that household.
Again, if you just joined us, yours truly, Warner Lewis from the flight deck of Lewis at Large Radio. We're talking with local attorney Sally Kelsey. Much of her work for the last 2.5 decades or so has been specifically with workmen's compensation. Sally, so are there, in fact, still federal laws of any kind specifically about workmen's compensation? And if there are, do they supersede or they work in Congress with local and state laws?
Not really. There are federal laws that affect things that occur in workers' compensation. There are federal laws that cover workers in the federal system, railway workers and types of workers, but anybody working within a state is going to be covered by that state's law, which vary. One of the ways in which federal laws can affect a workers' compensation case to some extent are things like OSHA and the ADA. The ADA in particular is something that employers need to be mindful of in workers' compensation cases, because when the employee is off of work because of an injury, they cannot be fired. It happens that they're not supposed to be fired, and when they come back to work, they have to be given their same job back. They have to keep that open for them. But if they cannot physically do that, then the ADA mandates that they be given any other job that's open for which that employee is qualified for. They don't have to just let that employee apply for the job. They have to place that employee in a job they have, if they have one that they're qualified for. And and that's a federal law. OSHA things sometimes come into play. There are times when an employee unfortunately has a bad accident, and the workers' compensation coverage may be well, in the case of a death, if you don't have any dependents, $25,000 for the remaining family. OSHA may impose a fine of, $60, $70, $100,000 on that company for some kind of violation that caused that person's death, but that person's family cannot sue independently. And so employers have to be concerned about workers being injured, not just because of what they may have to pay in premiums for their work comp coverage, but they also have to pay potentially wrongful termination cases, OSHA fines, things like that. So there's other reasons why employers need to be mindful of protecting their employees.
I would assume, I guess I can know the answer to this one, but I know you do a lot of work representing workers. Have you ever represented companies in these kinds of cases in any way, and what's the difference in terms of perspective?
I have not represented any employers at all. I am an employer myself, and so I have that perspective only in that regard. And I also have friends on both sides of the aisle, as it were, that represent employers. So I understand their concerns. And the Kansas Department of Labor has a seminar each year where they invite both claimant attorneys, as like myself, as well as respondent attorneys and adjusters for insurance carriers. And many of those talks are designed to give a comprehensive view that I think helps all of us see the perspective of the other side. For example, I have a lot of hearings on the issues of providing my client additional medical treatment, because typically they will hire doctors who will minimize the treatment, not want to do things, assert that things aren't related or that they're not needed. And of course, my client has a doctor who says just the opposite. 80% of the cost of workers' compensation payouts from insurance carriers is for the medical side. So that is why I have so much litigation on that, because that is their main concern, is minimizing those costs. Of course, my concern is getting my client those treatments as soon as possible so they can return to work, because the longer they're out of work, the more likely they'll be terminated or that their position won't be there anymore. The employer is more and more reticent to get them back to the workplace out of concern for their capacity to do that and for production purposes. So those forums provide an opportunity to understand a little bit about the other side. And with respect to employers, I will also say that I think it's been unfortunate in recent years that there's been so much watering down of the rights under workers' compensation and so much focus on business that really the Department of Labor Division of Workers' Compensation seems to be taking a tone that there is a natural adversarial relationship between employees and employers, and I don't think that that's conducive to strong economic development and cooperation, because employees want to work, and employers are more successful if they have productive, happy workers. And myself as an employee or employer now rather, I don't want to pay a workers' compensation premium to a company who turns around and does not provide the benefits that I expect them to provide to my employee. I want her back to work when she's injured. I want her to see a competent doctor, and I want her back. I don't want them to try to minimize what they have to do to try to get less treatment to her than she needs, because she needs to be back here and productive for me, and I'm paying for that. So I think that it's short-sighted to assume that these interests are different. And the other concern I have, certainly as an employer, is that if the workers' compensation laws in Kansas are determined to be unconstitutional, which has happened in a couple states, and certain parts of other states' acts have been found to be unconstitutional, then I could be sued for liability. If my employee falls down the steps and workers' comp no longer covers that because they don't cover things that don't have to do exactly with the work, and the new law is interpreted to say, well, even though you're at the workplace and you're leaving your work or you're coming in or you're bringing in something, walking up the stairs is not a work duty, and therefore we don't cover you. Well, then she can sue me for personal injury and get a heck of a lot more money out of me than if she were to be under the workers' compensation umbrella and being covered in that manner.
In general, without getting terribly political here, are workmen's compensation laws and the protections afforded to workers as well as their employers, are they fair? Are they decent? Are they up to date? Or in your opinion, what maybe needs to be changed?
They're actually extremely low, and they're not at all up to date. In fact, our benefits are probably somewhat less than what they were in 1994 when some of the first laws were changed in Kansas. And as a matter of fact, right now, they just made one final change to the workers' compensation law that I think will solidify the arguments for it to be found unconstitutional, and that is that they have adopted the new version of the AMA guidelines for the evaluation of impairment, which essentially means that someone who, under the old guidelines, which the statute adopts, you might have a 20 to 25% impairment when you herniate a disc in your neck and have surgery. Now the guidelines indicate that for that surgery, whether or not it's successful or not in relieving the problem and the pain, and whether or not it leaves you with limitations, your disability level is 3 to 8%. 8% being something that a workers' compensation doctor would never give if the surgery. So what that means monetarily is that someone making $40,000, $50,000, $60,000 a year who herniates a disc shoveling asphalt or driving a concrete or what have you, they will, under most, if not all circumstances, get a total $7,700 in compensation for their injury after they're done being paid their weekly benefits. And weekly benefits are limited to $595 a week now. So if you're used to bringing home $1,000 a week, what happens is you don't get that. You get $595 until you're done with your treatment, and then you walk off with $7,700. That is what, since January of this year, that is what the benefit package would be for somebody in that situation with a serious injury. And unfortunately, that's whether or not you lose your job or not. And so this is why a lot of us are concerned, and Republicans as well as Democrats, to be political, are concerned that there may be a constitutional challenge that's going to come up specifically related to the benefit level.
Sally, what about, again, you mentioned somebody shoveling asphalt, and probably a lot of our listeners think, well, workman's comp is really primarily focused on those that do a lot of physical work, that use their bodies for the work, so to speak. What about if you move to the world of the white-collar worker, what kind of claims would you see there? Is that, and again, does workman's comp cover somebody falling in a parking lot, or is it more carpal tunnel syndrome, so to speak?
Both of those are claims that can be raised. Right now, carpal tunnel is a condition that is fairly rarely covered just in the last few years because of the way the new law has been changed. One of the changes in the law that occurred in 2011 is that your medical condition must be primarily related to the work, and that is that the work must be the prevailing factor for causing the condition. And the treatment that you need must also meet that same criteria of the prevailing factor. Anybody who's over 40 years old is going to have some pre-existing degenerative changes in their body, even if they don't know it. So one finds that in cases where you have a fall or an injury at work and hurt your back, you're going to have a doctor look at you and say, well, you had some pre-existing changes. It's hard to say whether your excruciating pain and your radiating symptoms down your leg were there before or not. And if it's not, you aren't going to get covered. And in the carpal tunnel area, that is very much more the case. It's called a repetitive use injury. And so for those, of course, you can imagine there's lots more factors, such as age and other activities of daily living that you might do that would also come into play with respect to the evaluation of that prevailing factor thing. And so, and there are a lot of doctors out there, workers' compensation doctors, occupational health doctors, who will say, women have a propensity for carpal tunnel. People over a certain age have a propensity for carpal tunnel. And for those reasons, cases that have been litigated and gone to the Kansas Workers' Compensation's Appeal Board have pretty clearly denied that for a substantial number of those cases. It's really challenging to get $1 of coverage for those types of situations. And the other element that comes into play with repetitive use is that they've changed the definition of accident, and they've narrowed the window in which you're required to give notice to your employer of an accident. And so you have to give notice of your accident within 20 days, and it's actually within 10 days if you've been terminated or quit your job. So you also have to give them notice of the accident within 20 days of that accident. Well, the accident date is defined as the first date that a doctor gave you restrictions for something, or the first time you saw a doctor who said this is related to your work. Well, guess what happens? You see a doctor. 3 months later, you're still seeing this doctor for the thing, and he says, I think this might be related to your work. Well, you're already out of time. You didn't give your employer notice 20 days from the first time you saw the doctor and got restrictions. So there's been some litigation lately about that, and there's been some clarification because it makes absolutely no sense for you to be out of time for making a claim before you ever knew you had a claim. And so they have had to kind of be reasonable about the interpretation of that and essentially say, okay, well, you can't have a notice requirement until you're aware of the accident. So the notice starts running in a way that kind of closes a gap for that logistical problem that the law created. And so those types of things are litigated quite frequently, but in particular with those types of injuries you find in the white-collar type positions where it's a repetitive use thing where people are not quite aware that something going on with them is related to their work.
Again, we're with Lawrence attorney Sally Kelsey. Her area of specialty is workman's comp. Sally, as we start to kind of wind down here a little bit, rank for us, if you would, from your perspective and the many years that you've been involved in this kind of work, 1 being absolutely outstanding, 50 being the worst. Rank Kansas on a continuum of the 50 states in terms of what I guess would be the fairness and the thoroughness, so to speak, and the comprehensiveness of workman's compensation laws in Kansas specifically.
Oh, I would say we were probably the second or third worst in the country. One that is worse is Florida, and a Dade County court recently found one part of their Workers' Compensation Act to be unconstitutional as applied. But we are definitely on the low end, but there are several states lining up to get worse. And so that may fluctuate a bit, but certainly a couple of years ago we were all agreeing that we were on the low end of that. And the way that the cases are evaluated and considered in the administrative process has some impact on that, but it's mainly the actual design of the legislation, the way that the legislation restricts the definitions and the rights that there are, because those are all very limiting and they are interpreted by administrative law judges appointed by the Department of Labor, and they have to interpret them the way that the legislature wrote them. And right now, it's just everything's narrowly construed, and there are many types of injuries that are simply no longer really covered, and that coverage that exists does not compensate people for the economic consequence of an injury. And that's been the case for years, but it's certainly gotten worse.
Well, it is a large subject, and one that it seems to, whether you like it or not, does turn political from time to time, I'm sure. We've been talking again with Lawrence attorney Sally Kelsey for over 20 years, has specialized pretty much in workmen's compensation. Sally, how can people find out more about their rights, so to speak, specifically about workmen's comp if they are not getting it from where they work, and how can they find out more information about what you do?
Well, the Kansas Department of Labor has a very good website under their workers' compensation division that has forms for people, that has information for people, that explains how you make a claim. It is also very important, in my opinion, to call an attorney to help represent you. Attorneys are limited by the same statute to compensation of no more than 25% of any money they can recover for a worker. So it doesn't cost any money for them to do however many months or years of work to get you some recovery on your case, and you pay a percentage of any final settlement you receive. And so it's a good idea. I talk to people all the time that do or don't hire me, but that need some direction. And sometimes one of the directions I can give them is to go to that website at the Kansas Department of Labor. But it's very, very important to make your claim known, and to understand that when an insurance carrier tells you this is what we're going to do, or that this isn't covered because of this, they are taking a position. They're not telling you what the law is. You need to talk to an attorney if you want to know what the law is, what your rights are, what you can do if you have a dispute between what you need and what the insurance carrier is willing to do. And they cannot get in trouble for failing to provide you benefits unless you have docketed your case with the state and been given a judge assigned to your case and move forward with the process of having a hearing. It's quite easy to get a hearing in front of a judge once you've applied to get your case docketed. It's free of charge. You send the employer a letter explaining what you're demanding. Then you ask for a hearing, and you can bring your medical documentation to that hearing, and a judge will within 5 days issue an order regarding whether or not you are in fact entitled to the benefits you're seeking or not. But if you don't file that paperwork, then you don't have that opportunity. So it's important to just not feel like the bad guy and get in there and file what you need to file and get some direction, because lots of attorneys are out there that can help facilitate these things.
Well, we appreciate the information and the input, and thanks so much for sharing part of your day with us today.
Thank you.
You bet. We'll be back with more right after this on Lewis at Large.